Now, I have a lot of concerns regarding this case. Yes, Mr. Robinson was in the act of committing a crime by being a felon in possession of a firearm, but no one other than Mr. Robinson knew that until after he was frisked. Yes, the stop was legal since the officer observed the occupants driving without their seatbelts on. The constitutionality of seatbelt laws is a question for another day. But how does a seatbelt violation become a reasonable suspicion to frisk the passenger? Yes, there was a tip that the passenger was armed, but that was an anonymous tip, though, meaning there was no way that law enforcement could follow up and validate the tip without violating the rights of Mr. Robinson. And since it is legal in West Virginia to carry a loaded firearm with certain restrictions, how is a tip reasonable suspicion of a crime? Now, according to court records, Mr. Robinson was only identified as a black male, so there was no way for police to search his record and identify him as a felon, which would be necessary to reasonably lead them to believe Mr. Robinson was committing a crime of a felon in possession. I understand the bias to fight against Mr. Robertson. After all, he was found to be a felon in possession of a firearm. But do the ends justify the means? What's to prevent law enforcement from stopping you or another innocent person simply because they were observed in a perfectly legal act of loading a firearm and concealing it on their person? There are some places where I'm not allowed to carry my firearm, so I lock it in my vehicle. When I exit, I check my weapon, then put it back in its holster. Should someone observe me doing this be sufficient for me to be frisked by law enforcement, especially here in Tennessee where permitless carry is legal? Is that not being considered guilty until proven innocent? The courts may have had an easier time finding the frisk unreasonable if Mr. Robinson hadn't been a felon. Then again, hindsight is 2020. At the time of the stop, Officer Hudson and Captain Roberts had no reasonable, articulable suspicion that Mr. Robinson was a felon or that he did not have a carry permit. So, under the precedent of Terry versus Ohio, the police had no reasonable, articulable suspicion that Mr. Robinson was committing a crime, making the frisk an unreasonable search, violating the Fourth Amendment and Mr. Robinson's rights. This violation of Mr. Robinson's rights was compounded by both the district and circuit courts who heard the case. I guess under current federal jurisprudence, the ends do justify the means, and gun owners are considered guilty until proven innocent.